Assalamu alaikum, my name is Sandara Noor, and the topic that we will be studying today is rule of law. Rule of law is a constitutional principle and it is covered under the subject of public law. Public law was previously known as constitutional and administrative law. This area of law pertains to the affairs of the state and how to run a state. It does not relate to the civil rights or personal rights possessed by an individual. Rule of law can be found in weaker and stronger sense in almost all the constitutions and legal systems of the world. Primarily, rule of law is supposed to mean, in simplest words, as those with power should exercise their power according to law. The principle is directed towards executive, which is the government or those who have been elected by the people to exercise their powers if authorized by law. As fundamental and challenging as this may sound, yet there are some intricacies involved because of which rule of law sometimes can be not really found in legal systems. Whether it is the Western liberal society or whether it is in its underdeveloped or developing states such as Pakistan, India and Bangladesh. Rule of law is divided in two parts. One interpretation is known as the narrow interpretation. This simply means that those with power should exercise their power according to the law. Mostly this interpretation of the rule of law is found in countries like I just mentioned, which do not have a developing legal system. This means that the citizens of such a country are only supposed to follow the law and not really question, which means that if an executive makes a law which exempts them from following the law but asks the citizens to follow the law, whether it's a good law or a bad law, the citizens will have to follow it without questioning it. One can say that this leads to tyranny, and such an interpretation of rule of law can be found in states which have dictatorship imposed on them. The other interpretation of rule of law is the wider interpretation, which is also known as an interpretation mostly found in Western liberal societies. Now, the wider interpretation is further divided in two parts. The first part is that those with power should exercise their power according to the law. But the second part is that the human rights of the individuals should be protected at all costs. Now see, the difference between the narrow and the wider interpretation is that in a narrow interpretation, if a law passed by the government infringes the right of the people, it would still be considered as legal. So for example, tomorrow a law is made that only the working class has to pay their taxes. Regardless of how absurd this may sound, in a country where the narrow interpretation of rule of law is followed, this would be considered as all right, because the interpretation of rule of law for such developing constitutions is only to follow the law regardless the content is good or bad. However, in the Western liberal societies which impose or which have designed their constitution based on the wider interpretation of rule of law, unless the human rights of the individuals are not secured, such a law cannot be deemed as a good law and will not be followed. Moving on, rule of law was many have attempted to define rule of law. However, the credit for defining rule of law goes to Professor A.V. Dicey. Now, Professor A.V. Dicey basically said that there are 3 points which, if fulfilled and which, if found in a society, we can say that rule of law has been established in this state. Before moving on and before dissecting the principle, I would like to, in very informal words, just explain that rule of law basically means that the governance, and as the words to combine hint words, should be of law. It cannot be of the people. By people I mean, like for instance in Pakistan we have this thing, a very unfortunate situation, that if you're a son or a daughter of one of the ministers, or somebody who is in bureaucracy, and if you have if you commit a criminal offense, mostly they get away with it because they say that, oh, my relative or my father or my mother or somebody related to me is in, working in a certain ministry, or is, working on some big position. A landmark case which had jolted the courts of Pakistan was that of Shahrukh Jatoi and Shahzeb murder case, which is a prime case and a prime example of lack of rule of law in Pakistan. The case involved basically one individual murdering the other one, and the defendant had a very long run in escaping the law, and eventually he was convicted. But primarily it was very difficult to corner the defendant, because he used to state and claim that because he was related to somebody very powerful in the executive, therefore the law does not touch him. Mostly if you ever watch the television in the evening, the 8 p.m. talk shows or the 7 p.m. talk shows, the panelists, they do discuss the principle of rule of law and how it is lacking in a country like Pakistan. In countries where the rule of law is intact, corruption, accountability, and imposing of laws, it's the monumental and the most fundamental aspect of the legal system. However, if your country has a very weak implementation of rule of law, the principle, let me please reiterate that rule of law is only a principle, a theory which is supposed to be found in the workings of the state. It's not a law that has to be binding. There's a difference between law and a principle. A principle is not a rule that has to be followed. A principle is basically a theory which can be found in weaker or stronger sense in the society. Moving on from here, so Professor A.B. Dicey basically dissected the principle of rule of law in 3 parts. His first part was, the first point was that those with power should exercise their powers according to the law and should not exercise discretion. The use of power should not be arbitrary. This means that if you are a minister or a prime minister or head of any department, a government department, whatever actions you're doing cannot be based on discretion. They should be based on some rule or some law passed by the parliament. However, Jennings, who was a critic of Mr. Dicey, he stated that discretion is somewhat required by the states, because if an unforeseen event occurs or a natural disaster occurs, the state cannot, be bound by so many rules and so many regulation and so many formalities, and it needs to exercise its power discretionary. So for instance, when Pakistan was hit by floods, or when the UK was suffering from the effects of war on terror, a certain amount of discretion is always allowed. Otherwise, things which can be done basically maybe in 2 days will then lead up to be done in 2 weeks. Moving on to the second point. The second point of A.V. Dicey was that the law is equal for every man irrespective of his or her rank. Again, something which is ideally expected from all the states, but theoretically it is expected, but practically it cannot be expected to be performed, because if you look at the Western countries such as USA or UK, or if you even look at states like North Korea, Pakistan, India, Bangladesh, all citizens cannot be treated equally. It is an ideal expectation, but it cannot be performed in such a practical manner. The reason being that ministers, ambassadors, diplomats, they have certain immunities which an ordinary citizen does not possess. So one such instance is that in all the Commonwealth countries such as the Pakistan, UK, India, Bangladesh, Sri Lanka, Nepal, Canada, Australia, in all these countries, if you defame somebody verbally, or if you write it or publish it somewhere, you will be held liable for that under the law of tort. But if you are a member of parliament and you defame somebody within the boundaries of the parliament, whether it is within the building or outside in the garden or the lawn, you cannot be held liable. Another immunity that people who sit in the parliament or the executive possesses, that if a civil case summon, which is like if the courts calls on you for a case you are involved in, a civil case, and you say that I have a parliament session that I need to attend in few days, you will be exempted from appearing in the court, and a normal individual does not possess such an immunity. So perhaps it can be stated that Dicey's point, although making a lot of sense, cannot be really found. This criticism was again posed by Sir Ivor Jennings. Moving ahead to the last point of rule of law, which was defined by Professor A.V. Dicey, is that most of the rights found in UK are a result of the judiciary's hard work. He gave credit to all the not all but most of the important human rights found in UK to the judiciary of UK. Now please note here that UK does not have a written constitution, which means that the law in black and white that the UK relies on is passed by the statute, is passed by the parliament, and Mr. Professor A.V. Dicey has given the credit for human rights not to the acts passed by the parliament, but rather the case law and the common law developed by the judiciary. Again, he was criticized by not only Professor Ivor Jennings but many other individuals as well, who stated that the Human Rights Act 1998, which is a landmark statute passed by the Parliament, whereby the European Convention on Human Rights was incorporated partially as into the UK legal system, was absolutely ignored. But perhaps this was also because Dicey had died by the time HRA 1998 had come into existence. But nevertheless, his point is it's totally irrelevant, because acts such as the HRA have contributed greatly to the human rights of protecting the human rights of the citizens of UK. Now, after discussing what the rule of law is and how it was dissected by Professor A.V. Dicey, and Sir Ivor Jennings had criticized the 3 points definition which was created by Professor A.V. Dicey, we next discuss that if the principle is found in the UK, the UK, which is given the credit of inventing the principles of sovereignty of parliament and the rule of law. Whenever we need to establish that if a constitution or legal system possesses a principle, whether in the weaker sense or the stronger sense, we look up to statutes passed by the Parliament of UK or whatever legal system is in question, and also look at the case law. One such case which indicates that the UK did possess rule of law and still does is of A versus Secretary of State, which is a landmark case wherein for the first time a bench of 9 judges had sat to give the decision on this case. The majority was of 5 and the minority was of 4, and what happened in this case was that individuals who were suspected to be involved in terrorist activities were detained indefinitely and were also tortured on the basis of suspicion only. This was a direct infringement of human rights because an individual who has very weak evidence against him, and it has not been yet proven that if he has committed the terrorist activity or not, cannot be indefinitely detained and also tortured. This was all happening according to an act, a law passed by the Parliament of UK known as Crime and Security Act 2001. Not only was this challenged in the Supreme Court, which was then known as the House of Lords of UK, but it was also defeated. The act was defeated under and by the Human Rights Act 1998 because of discrimination. One reason that the act, the 2001 act, was posed only towards those people who were non-British. So if you're a student who has applied to a UK university and you're studying in UK university, you become a suspect under 2001. But if you are a Britain citizen, then the act does not apply on you. And furthermore, the use of torture was challenged, and both these points were defeated under the HRA 1998, and the court held that the 2001 Act should be placed aside. Those provisions should be set aside which basically instigate towards torture, and which also take away the liberty of the individuals, and which promote torture, and which also are discriminatory in their application. There are other such cases which can also be found, which can establish the point that the UK does possess rule of law. One such case being of Malone, whereby Mr. Malone challenged the state because his phone calls were being tapped, and he considered this to be an infringement of his privacy, and the International Court of European Court of Human Rights, as well as the House of Lords, which is, I just stated, is now known as the Supreme Court of the United Kingdom, held this in favor of Mr. Malone. And another case which also establishes that the UK does possess rule of law is of Entic versus Carrington case, whereby some government officials and the police had come into the house of Mr. Entic to look for some smuggled items in his house, which Mr. Entic thought to be trespassing into his property, and the courts found in his favor. However, if for the sake of discussion we wish to know that if rule of law is found in Pakistan or India, we can say that it lacks warrant, because Pakistan has numerous cases where rule of law was abused. The Mashal Khan case, the Khadija stabbing case, these are some of the very popular cases whereby the citizens took law in their own hands, or the officials abused the law without considering the merits of the situation or the rules, such as the Sialkot killing cases or the Sargodha killing cases, the Model Town case. These are some local examples where you can see that Pakistan still has a long way to establish rule of law. Similarly, if our neighboring country India is to be considered, then they recently passed a Citizen Amendmentship Act whereby they are discriminating between two races on the basis of religion, which is Hinduism and Muslims, and they have established some concentration camps whereby individuals who cannot give evidence of how their forefathers had come or remained in Pakistan before or after the partition shall have to then live in a concentration camp, and obviously torture or abuse of their human rights is part and parcel of staying in that concentration camp. Many numerous abuses of human rights and law can also be found in states like North Korea, and to some extent you can also say in states such as the USA. Although USA has some accountability of still a lot of accountability of the actions of its executives, however, still the civil rights, the abuse of civil rights that the other ethnic races that they are suffering from in USA shows that the USA also has some issues of rule of law in within them. I would like to wrap up this session on rule of law. Thank you.